Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 39, we're going to talk about portability elections. In other words, elections you can make to preserve a deceased spouse's unused estate tax exclusion. And we're going to look at some of the filing deadlines and the fact that with Revenue Procedure 2017-34, it is possible to make late portability elections, but maybe it's not a good idea to rely on that. As always, this presentation is not intended to substitute for legal or tax advice. Now, portability, as I mentioned, allows a surviving spouse to use a deceased spouse's unused estate tax exclusion. As you recall, that estate tax exclusion is currently 11.58 million, indexed for inflation, but it may be reduced by up to 1/2 in 2026, if not sooner reduced by legislative action in the next year or two. Now, if you want to make the portability election, this is accomplished by filing a timely, complete estate tax return. And we'll look at what that means in a minute, but here's a quick example of where you might see this kick in. So H, husband, dies with an estate of only $3 million, and he leaves all of that to wife, W, in a Q-tip trust. We've talked about Q-tip trusts in the past, and that'll be its own separate discussion, maybe to cover in great detail in the future. But what this means is that at least 8.58 million of H's 11.58 million estate tax exclusion is unused. So the executor of H's estate has several elections they can make, which will affect the size of the portability election. So H's executor could make a full Q-tip election, which would preserve all of H's unused 11.58 million exclusion for W, or they could make a partial or no Q-tip election to preserve at least 8.58 million of exclusion for W and apply up to 3 million of H's exclusion to the unelected portion of the Q-tip trust. So Q-tip elections are a separate discussion, but that's really a switch you can turn to determine in whose estate, husbands or wives, the assets would be taxable as long as they're in a qualifying marital trust structure. But that aside, what is a timely filed estate tax return? Well, the due date for the estate tax return is 9 months after date of death, and you can get an automatic 6-month extension for that as well for the filing. And in our return or in our facts above, one issue is that no return is required, and the only reason for filing is the portability election. So you have 15 months under traditional law to do so, but what if this is never done? A lot of times portability elections are one of those hindsight being 20/20 types of things where maybe you roll the dice and don't do it, or maybe you do it depending on what laws look like and whether any legislative changes are on the horizon, and maybe even whether the surviving spouse wants to make gifts. So if you've passed that 15-month deadline, the good news is that the IRS does allow for a late portability return. It can be filed up to 2 years after the date of death of the deceased spouse. And the procedure to do so is set forth in Rev Proc 2017-34. The return must be complete. We'll cover that in a second. And then you must place at the top of page 1 of the IRS Form 706, the estate tax return, the following notation. You must say that it's filed pursuant to Rev Proc 2017-34 to elect portability. And if you miss this 2-year deadline, you could potentially still have a late portability return, but you have to get a letter ruling under the Treasury regulation that authorizes late elections, which is a pretty involved and expensive process. So what is a complete return? Well, usually you have to give a full description of the property on the appropriate schedules, and you have to substantiate the fair market value of the property either on the date of death or, if elected, on the alternate valuation date. Now, because you have to have a taxable estate for the alternate valuation date, you're practically never going to use it on a portability return. Now, any property eligible for a marital deduction or a charitable deduction doesn't have to have a full substantiated valuation. You can leave the value of that property blank, and instead the executor can estimate the value and report a total range for marital deduction or charitable deduction property based on increments of $250,000. Now, the trade-off for doing so is that you will underestimate the unused exclusion that's left to the deceased spouse. So an example would be, maybe we have H who leaves $3.58 million to W, and that $3.58 million qualifies for the marital deduction. Now, on paper, H has $8 million of unused exclusion. However, if we're going to use this value estimated rule, the executor would have to round up that $3.58 million to the next increment of $250,000. So they'd have to report $3.75 million, meaning that the full unused $8 million won't be preserved for W. Instead, W will only get $7.83 million of an unused exclusion preserved for her benefit in this case. So portability returns can be a great boon right now, especially since the estate and gift tax exclusion may go down in the near future, and this can be helpful for making gifts if those are planned as well. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of the 10th of an Hour, and I look forward to seeing you in the next one.